My lord, senior is waiting.
Yes, yes.
May I seek my lord's kind indulgence to mention one matter? This matter was taken up by the Honorable Division Bench, said by your Lordship, you are sitting with Justice Bittu. My lord, we took adjournment. But I am the respondent in the appeal. And my lord, the matter was, your Lordship's pleasure was that the matter should be posted after, my lord, 1 week after vacation. Puja vacation. But there is no judicial order, my lord.
No, is it you are mentioning upon notice?
Yes.
Give this slip.
Yeah, no, yes.
একটু দেখে নিও
Lordship.
My lord, may I mention, my lord, one appeal lordship. This was, my lord, mentioning upon notice. Your lordship's, my lord, past and direction, my lord, for liberty to mention, and my lord, appointment of commissioner. This learned commissioner, my lord, his report is ready, my lord. He has communicated to us, my lord, and liberty to mention was given before you. By your
original
lordship.
side.
No, lordship, appellate side. It was, my lord, specially assigned, my lord.
Lordship, may I have your Lordship kind leave to file one application? Lordship, this matter is pertaining to the Jiaganj Nursing College matter. The matter was taken up before your Lordship on 31st of October, wherein the university was directed.
We can't give it.
Lordship, mentioning
Your
upon
notice.
Lordship, this
We
matter.
told your senior that give a notice and mention.
Lordship, we intimate everyone on the previous occasion. Previous day, this matter was previously mentioned by Mr. Mojumdar, Lordship.
Your notice today. Where is your notice?
Lordship,
how will they come to know?
Lordship, after file, I shall give
That is
notice
not the
to.
procedure. এটা কি বল?
Lordship, this is very urgent, Lordship, because the examination is going to be held on
We are
11th.
asking you a simple thing. We told that give a notice, make it aware, let the court be aware, others be aware. Otherwise, you cannot be
I
done.
apologize, Lordship. I will notify everyone, Lordship. Kindly take up this matter.
The notice given that you have mentioned and it will appear, we will not take up the matter tomorrow.
Lordship,
File the application, give the number. You have to file the application.
Lordship.
So give the yes. Go back.
May I be permitted to mention, my lord, one application? I'm mentioning upon notice, my lord.
Group 2.
Group
Group
2
2.
application, my lord.
Was it hard earlier?
Yes, my lord. I guess it is hard earlier. I'm not properly instructed, my lord. Is it hard or not? But it's the application.
You don't know whether it was hard.
No, my lord.
Slipটা নিয়ে নাও দেখে নাও।
Your Lordship, may I be permitted to
Grateful, my
mention? Group 8 matter, the file is lying at court number 16 for inclusion, Your Lordship.
Application
Yes, sir.
or final hearing?
For application.
If this you
My lord-
gave notice. Where is your notice?
Your Lordship,
Give a notice and come back.
for inclusion,
Right.
Your Lordship.
It is ascertain whether is it a fresh application? It was
It's
hard
a
earlier.
fresh
You just now said that
application.
was it
Application.
hard earlier?
I'm not instructed on that.
When was it filed? Application?
Court number 16, the file is lying.
Court number 16, the file is whether anybody appeared for the respondents.
Your Lordship, I'm not aware of it.
So please be aware and mention. Ascertain, give a notice, come back and tell us on Monday. Yes.
My lord, non-prosecution, my lord.
এই দেখো ইন পার্সনটা কি বলছে।
মাই লর্ড, আমি মোহাম্মদ শামীম, মালদা থেকে ইন পার্সনে পিটিশনার। আমার এই কেসটা আগে উঠার ছিল, কিন্তু অন্য বেঞ্চ থেকে এখানে না আসায় এটা উঠেনি মাই লর্ড, ওই জন্য মেনশন করছি। একটা ডেট দেওয়ার জন্য।
অ্যাডভোকেট সাহেব আছেন? আপনার অ্যাডভোকেট সাহেব আছেন?
না,
আপনি নিজেই ফাইল করেছেন?
নিজে থ্যাংক ইউ মাই লর্ড।
Yes.
পুরো সারছে না। Yes.
Lord, it is a 2020 recruitment process under West Bengal Board of Primary Education, my lord. Initially, my lord, for decategorization, the 19 read petitioner moved before this Honorable High Court. That is in page 43 of my read petition. I have handed over.
Is it 2016?
2020.
The
2020.
court has proceeded on the basis of 2000.
That was erroneously, my lord. Thereafter, my lord, it has been corrected in the latter order.
corrected.
Yes, 25th of June 2024 order, my lord. That is, my lord, page.
Yes.
Also got it. 2020 recruitment process. On the strength of judgment passed by the Honorable Supreme Court, my lord, our candidature was not considered. Lord, and accordingly, the order was dated 29th of April.
No, what will be the ultimate?
At first, your lordship kindly sees the order dated 29th of April 2024 in my state petition, page 12.
Yes, so that goes.
Yes.
That
thereafter, order was corrected.
After correction, it was in the no relief can be granted.
Yes. After correction of the order, my lord, we have filed an application for review. Your lordship kindly come the review order dated 2nd of April 2025, page 16 of my stay petition.
That is not in the memo of appeal.
That is in my stay petition, my lord. The order dated 2nd of April 2025.
Then you are preferring appeal against which order?
Lord, initially, my lord, we have preferred an appeal against the order passed by the order of review. According to the honorable,
That is not maintainable.
that is not maintainable. That's why, my lord, we come before your lordship by afresh file the appeal, my lord.
Show us the review order.
Yes, that is in stay petition, page 16. Order dated 2nd of April 2025. See that.
Yes. Then what happened?
That order was challenged initially, my lord, before of this coordinate bench. According to the honorable division bench, the order the appeal is not maintainable. That's why this appeal has been prepared, my lord. Now, my lord, our case is this. Initially, in my read petition, or page 43 of the lordship, kindly first order dated 22nd of April 24th February
No,
2022.
if the review order remains, review application or appeal against that review order has been dismissed.
Not maintainable on the ground.
Now, the review order is there. Now, how can we go back to the earlier orders? Because then the review order you have to challenge before the Supreme Court. Correct us if we are wrong. Review, an order was passed by the single bench. That was corrected. After correction, you sought for review.
Yes.
Review was disposed of.
Yes.
You were agreed by the review order. You were agreed by the review order. That is why you preferred appeal against that. Appeal court said review is not maintainable. Now, unless this review, how can we interfere with the review order?
No, Lord, we are challenging. We have not come here against the review order, my lord. We have come here, my lord. We have come here against the correction order.
That's not review order.
Correction order dated 25th of June 2024.
Which 19 যেটা ওই যেটা stay application announce করেছে. Which review order is at page, Mr.?
Page, my lord, 16. 16. Review order dated 2nd of April 2025. That is review order.
Now the review was dismissed.
Review was disposed of.
That no relief can be granted.
No relief can be granted in terms of the order passed by the Honorable Supreme Court in Ali Hossain's case. Due to expiry of the life of the panel.
Now this review order
was
after dismissal of the appeal as non-maintainable.
Yes.
This review order attains finality. Unless
here, my lord, we have come by challenging the order dated 25th of June 2024 by leave granted by this honorable division bench. That is, my lord, page order dated 19th of May 2025, page 17 of my stay petition, my lord. Page 17, 19th May 2025.
রিফিউজ করছে রিফিউজ হয় অরিজিনাল অর্ডারটা
এটা লিবার্টি দিয়ে রেখেছে
Well, I am extremely sorry, I have only one copy. 9th of May 2024.
একটা কপি তো আছে যেটার সঙ্গে ওটা পেজ মিলবে না।
29 বলে দিল
দুটো কপি, এটা ডিভিশন বেঞ্চে আমি
petition was
In the year 2022.
prior to May 2022.
Yes, prior to May 2022. And we wrote present read petition in the year 2024, month of April, prior to Ali Hussain's case, my lord. An order was passed 29th of April. That order was corrected on 25th of June on the strength of this judgment, my lord.
এটা একটু স্টেপল করে দাও না। Yes, Mr. Vishas, what is your
my lord, apart from my lord, what is fallen from your lordship, my lord, ultimately, my lord, the after order of the review, my lord, the main order already reviewed. My lord, now, my lord, he has, my lord, the come before your lordship, my lord,
challenging that order?
challenging that order.
The
My lord,
correction
The
order.
correction order.
correction order. My lord, my humble submission, my lord, he should go, my lord, before the Supreme Court, my lord, first.
But
My lord, leave is granted by the division bench to move, my lord. My lord, and my lord, there is a delay, my lord. I'm not, my lord, I'm just straight away, my lord, answering the merit of the, my lord, matter. My lord,
No.
apart from the delay.
no, what I was thinking was review order attend finality.
Absolutely, my lord. Review order
So,
attend
but
finality.
But if the review order attains finality, that does not prevent him from challenging the parent order.
Absolutely, my lord.
That is what he has done.
Present appeal.
Right.
My
So
lord,
maintainability is not an issue. Now you submit on merit.
my lord, I am, my lord, no, my lord, I am on the maintainability, my lord, as well as the, my lord, the section 5, my lord, delay, my lord,
Why you are saying maintainability?
my lord, because, my lord, the review order, my lord, it reaches, my lord, finality.
Right.
The order was modified.
Right.
My lord, he has to question the, my lord, the order of the, my lord, the division bench, my lord, where the review was dismissed.
No, division bench
Has
granted him
granted leave, my lord. My lord, my humble submission, my lord, even that, my lord, he has to prefer an appeal, my lord, challenging the earlier order of the division bench. Otherwise, my lord, it reaches finality, my lord.
Which earlier order?
My lord, this review order, my lord, or the other division bench.
Tell us on
My
merit.
lord, I am on merit, my lord. My lord, your lordship, kindly, my lord, do just accept it. My lord, this is a extract copy, my lord, just 5 minutes back, my lord, I have received it, the instruction, I could not stitch, my lord, your lordship, my lord, kindly excuse me, my lord, just 5 minutes back, my lord, I have received it. I've got the printout.
You are not prepared.
I am prepared, My lord, your lordship, no, my lord.
Now, what is the story? Tell us.
My lord, I'm just, my lord, just giving, my lordship. My lord, they were impaneled
In
in
the 2020
2020 recruitment process
Very good.
under, my lord, exempted general category. Exempted general category. My lord, these 19 writ petitioners filed the writ petition. My lord, their case was I was not exempted category candidate. I was wrongfully impaneled. Whatever may be the mistake of either the board or the petitioner, that was not decided. My lord, the single bench, my lord, was pleased to direct us
to decategorize him, you put him in his actual category. If he comes within the zone of consideration, you give appointment. My lord, we accepted the order. Because whatever may be the wrong on the part of the either of the petitioner or the board, my lord, we accepted the order, we corrected it. But amongst the 19, my lord, we have given appointment 12. My lord, rest 7 are before your lordship now. My lord, your lordship, my lord, have handed over. Your lordship kindly consider the first page. Before that, your lordship knows the, my lord, the in the TET examination, my lord, TET is the eligibility criteria. You have to first TET, then you can only apply for the recruitment process. My lord, TET is, my lord, the qualifying marks is 90. My lord, 60% is the qualifying marks in the TET. And my lord, the 5% relaxation for ST, SC, OBC, and my lord, other my lord, the exempted all my lord. My lord, they declared in the TET examination that he was exempted category candidate. Somehow, my lord, he in the OMR sheet he marked as OMR as exempted category candidate. He got 5% relaxation.
And that was also obtained by the others.
My lord, I'm just coming, my lord. I'm just coming, my lord. Your lordship kindly for the time being, your lordship kindly, my lord, consider, my lord, 7. My lord, these 5, my lord. My lord, they got your lordship from the next page, my lord, the second page, your lordship will, my lord, get the score. Your lordship, my lord, I have marked it. Your lordship, kindly excuse me. That sideline, my lord, side, I have marked it. Your lordship will find Mousumi Bera. The second page. Yes. Your lordship, my lord, just I have given a mark, my lord.
Yes, exempted 84.
84. My lord, this is the marks of TET.
Yes.
My lord, if my lord, he is, my lord, exempted
TET
category
TET
candidate.
marks is how much?
My lord, 84. Mousumi Bera. My lord, your lordship kindly see Mousumi Bera and the right hand column. Extreme right column, my lord, 84.
Marks হচ্ছে 84.
84, yes.
My lord, since he was treated as exempted category candidate, my lord, he was
5%
qualified, got 5% relaxation. Initially, my lord, the after 5% relaxation, 82 was the 83 was the, my lord, cut-off marks. Ultimately, order of this our court, my lord, it was reduced to 82. It's a
So 82. So if he is given 5% relaxation, he was given 5%
5% relaxation, he declared pass. My lord. Then, my lord, he applied for the recruitment process.
Yes.
But if he was not given the 5% relaxation, my lord, it would have been, my lord, 90 is the, my lord, the pass marks. 90. The 60% of the TET. My lord, your lordship kindly consider 84. My lord, he himself, my lord, declared or my lord came before this honorable court said he is not exempted category candidate. So therefore, his basic qualification, qualifying the TET goes. So therefore, he is not a TET qualified candidate. My lord, if he is considered as
he claims himself to be the unreserved category.
Is a general category, only general, not exempted. If he is a general, he has to qualify, my lord, TET obtaining 90 out of 150. That is the 60% in my lord as per the NCT.
That was brought down, you said?
That was, my lord, I said
60%
of 150.
150.
150 of 60% comes to my lord 90.
Achha.
My lord, I said 50% initially, my lord, board considered
150. So he got 84.
84. So
now
therefore,
you said that the cutoff
I
was...
just not cut off. I said, my lord, initially when the board qualifying the exempted category or reserved category,
if 5% relaxation was given, his marks becomes how much?
My lord, he got 84 in
84
the TET.
he got.
My lord, initially we declared the reserved category candidate 83 pass marks. TET.
In exempted category.
Exempted. All reserved category. 5% relaxation, 83.
So 83 was the cutoff.
83 initially. After that, my lord, 82.
So he
right now 82.
So he comes within the zone.
If he is treated as exempted category candidate. Now he is saying he is not at all exempted category.
Now,
so therefore, he is not, basic qualification goes. my lord, he is unqualified in TET. If he is unqualified in TET, he cannot apply in the recruitment process.
5% রিল্যাক্সেশন
5% অর্থাৎ তখন ও এক্সেম্পটেড ক্যাটাগরি
না
বেনিফিট
তাহলে 5% রিল্যাক্সেশন অফ what?
As exempted category candidate.
That is 5% relaxation of what? Cut off or the
Qualifying marks.
কোয়ালিফাইড মার্ক 90
so
My lord, 90 comes to my lord 82. My lord, for reserve category, 82 is the qualifying marks. For general category, 90 is the qualifying marks.
yes
My lord, therefore, my lord,
90% পেয়ে থাকে তো ওর তো 80 রিল্যাক্সেশন পেয়ে 84%.
five I have annexed. My lord,
yes we have seen all are below 90
all are below 90.
all are below 90
So therefore, my lord, he is not getting 5% relaxation and he is not qualifying the TET. My lord, other 12, their marks were above, my lord, and they yes, they were qualified TET. And my lord, they were
Others were no all these 13 কত
12.
12 candidates were
12 candidates were considered, they came within the zone of consideration. That is why they were given appointment. But here, for these five,
total was what 19
90
Total 19.
my lord,
total 19 came
TET 9.
total 19 came
Total 19. Huh?
out of which you have given appointment to 12.
That my learned friend is
It is
saying
12.
12.
Hmm.
Now 5 is before your lordship.
Yes.
My lord,
Then
this is-
if you apply this rider, those appointed candidates also are not required to be considered.
Yes.
Those the 12 candidates.
no, their case is not now before your lordship. My lord, he is not saying
How
that.
much did the 12 candidates?
Definitely, my lord, after my lord, more than 90. Otherwise, they
No, no.
couldn't have, my lord, the qualify the my lord TET. And if your lordship, my lord, say for the argument, my lord, this is not the case. If your lordship consider, my lord, they were not passed TET. But at the best, my lord, their appointment will go. This is not the case, not the petition. This simple case is that we
Try
file.
to show us that all of the remaining persons got more than 90.
My lord, this is not the case before your lordship, my lord. Today, my lord, he's filed the
But
appeal.
today is the first time now they are taking the plea and we are not
My
qualified.
lord,
But
this
we have
question
some
never
document.
arises. This question never arises. My lord, your lordship kindly consider. This is not my chart. This is, my lord, even today, my lord, right
we
now,
understood. Now
it is
what
in
is
the
your
website.
stand? What is your
now,
stand?
now thereafter
My lord, my stand is, my lord, he is not qualifying TET, therefore he cannot apply in the recruitment process. Since he declared himself as a exempted category candidate, he was, my lord, qualified. He declared qualified. That is why he could apply in the recruitment process. He considered, he came within the zone of consideration as exempted general. He was empaneled.
But Mr. Vishwas, how can you take the point now?
Yes.
That point was there in the first writ petition where 19 were directed to be appointed.
Yes, my lord, when
They are in
19
that
was,
plan, that is
actually,
reflected all are
Yes,
TET
sir,
qualified.
will you wait?
my lord, absolutely, your lordship.
Hmm.
My lord, when we considered the 19, we have seen that the 12, my lord, within zone of consideration is coming. The code, my lord, your lordship kindly consider the order of the single
Cannot
bench.
proceed on assumption. He
No,
he
not
has a-
assumption. On the, my lord, not assumption. Your lordship kindly consider once, your lordship, the single bench judgment, that decategorization order. Your lordship once.
Yes.
Page 43 of my read petition, my lord. Petition টা কই?
Just once, your lordship.
Read petition.
Then your lordship, my lord, probably, my lord, I make myself clear, my lord.
Page 43, my read petition.
The petitioner applied for, my lord, may I read?
Yes.
Petitioner applied for participating in the recruitment process of primary school teacher in the 2016 recruitment process. My lord, it should be 2020.
2020.
Process initiated by the West Bengal Board of Primary Education. All the petitioners are TET qualified. The erroneously mentioned their category as exempted. Learned Council appearing on behalf of the West Bengal Board of Primary Education submits that the benefit of the reservation under the exempted category cannot be allowed in favor of the petitioner as the petitioners do not belong to the said category. However, it has been submitted by the learned counsel for the petitioners that
may be accommodated in
may be
accordance
accommodated
with their
the
respective
caste category and
categorization. After
decategorization.
decategorization, and there is every likelihood
the petitioner can be accommodated or enlisted in the list. In view of the said submission, the board is directed to take all steps for treating the petitioner in accordance with the respective card without extending the benefit of reservation. Your Lordship, kindly mark it. Extending the benefit of reservation merit for the exempted candidate. Steps shall be taken for decategorization of the petitioner in accordance with the recruitment rules at the earliest, but positively within a period of 3 months from the communication of this order. But after this order, my lord, we decategorized. All the 19 was decategorized. My lord, after decategorization, my lord, the 12, my lord, put their my lord, actual caste category and my lord, the medium, they came within the zone of consideration. That particular zone, my lord, before my lord, the much higher than the last cut-off candidate. That is why they my lord, were accommodated. In that particular group, they were given appointment. After my lord, 12 appointment, we found my lord, these 7, my lord, if the exempted lift, my lord, or exempted was not considered as exempted category, my lord, he is not passing the TET, he is not qualifying the TET. Then how can we, my lord, consider him as my lord, TET my lord, the candidate?
TET qualified.
Basic qualification goes. My lord, basic, he passed the TET on the basis of his undertaking or my lord, given it that he is exempted category candidate. That is why my lord got 5% relaxation, qualified the TET. Now when my lord exempted,
this is a totally new point you are arguing.
Yes.
This was never argued on behalf of the board. On
my
the
lord, this
contrary,
was
the
my lord,
board,
since your lordship last
can you show us that all the candidates who were appointed, how much marks did they get, whether they were TET
my
qualified?
lord, since your lordship is saying, my lord, I am, my lord,
We are forced to say because you are taking a new point, na?
my lord, this is not a new point.
This is a
in
new
the
point.
website, my lord, even today, my lord, long back, it is in the website of the board. He knew his marks.
No.
He knew his mark. If he doesn't know, my lord, if he doesn't.
Mr. Vishwas, kindly try to appreciate.
My lord.
In 2022, when the matter was heard,
My lord.
it was a fair stand on your part.
My lord.
That yes, we will decategorize. If they come within zone of consideration, we will.
My lord.
So when you made the decategorization, that was not relating to the marks in TET. That was simple.
My lord, simply, my lord, we
no,
said.
you show us then, if you are taking the point, please show us that the 12 candidates whom you gave appointed.
My lord, this 12 is not before your lordship today.
No. You are saying what? You are saying that as he is not TET qualified, question of consideration does not arise because he does not come within the ambit. His case is they have proceeded that 19% approach.
Yes.
Order was complied with in respect of 12, but not in respect of 5%. Now they preferred fresh writ petition. They did not go for contempt. Now you are telling when the
but they cannot file even the contempt because
very good. So, you have to first show us na, that you cannot extend the benefit to him because he is secured 84, which is below 90 being the prescribed mark, 90%. If those 12% you have made a departure, then the situation becomes difficult. If you can satisfy us, yes, all of those persons without relaxation got 90, then we can hold in your favor. Right?
My lord, even then, your lordship. My lord, even then, my lord, this is will be
moreover,
negative equality, my lord.
Before the honorable single bench, my lord.
In this list, whether those 12% are there?
Not this, but in the website, 12% are there.
Lord, I want to file exception, my lord, in this regard. This is the first time, my lord. Before the honorable single bench, they did not.
This is a public document. In the website, it is there.
We have filed an
for last 2-3 years.
General category. We have given fees which is funded by way of challan. Not at all, not at that point of time, we have submitted application under general category.
are doing is we will allow your section 5. So far as the stay application, he has taken a new point,
Yes.
which he says that is not a new point. However, he will disclose that in opposition to your stay application, and in reply, you deal with that statement. Only remedy which you are, that this your very right to be considered goes. Suppose if his content,
According to him, my lord.
according to him.
Yes.
So if you can show that this was not applied in respect of those 12 persons who were given, then you have a right to urge an issue of discrimination. But what is the problem is your eligibility is now.
Yes, I will place some documents where from your lordship will get it that we qualified in the TET 2014, my lord. I have some
there is no dispute.
Qualified securing 90 marks. Qualified
Yes.
securing 90 marks.
But, my lord, we have applied as a general candidate, not as an exempted candidate. We have given fees rupees 200
So
by way
then,
of
Mr.
challan.
Mr. Mukherjee, if you have applied as a general candidate, you must have to secure 90 marks for
Yes,
that.
yes.
So admittedly, he is showing an that
Now he is showing, my lord.
Man, last 3 years
Now
it is
he
in
is
the
showing.
website.
He
Last
makes
3
an
years,
Website.
3-4 years.
If he makes an argument, we have to deal with it.
Yes, yes, yes.
Available in public document domain.
Last 3-4 years it is in the website, my lord.
No, you know, but,
Can queue up 2025.
Grateful.
I am. DJR, the recommendation for transfer has been issued by the commission. Now it has been pending before the board is concerned. Matlab, kindly seize the order. Tomorrow is the date for verification of documents and testimonials. An appointment letter to be issued. Believe tomorrow itself, Mr. B. Bhattacharya is there. So matlab, kindly fix the matter on next Thursday under the same heading. Matlab, for this.
আমরা ডিসপোজ অফ করে
No, kindly. Matlab, we have a little.
রেকমেন্ডেশন ইস্যু দে উইল
They will let it be matlab, for our benefit also as well as the benefit of the client itself. Matlab, I must be candid to you, Lord. Let it be to be mentioned on any date next week after issuance of appointment letter. Now let it record our submission and let it be on next Thursday or something, any date. Matlab, next page is the matlab, day. Tomorrow is the date fixed for verification of documents.
But verification of documents for collecting of appointment letter.
Yes.
It is a transfer. So there is no verification of documents, only collecting of
then you will issue the appointment letter.
No, we have asked the petitioner, transfer order.
Then he will go to join.
Yes, she.
Come
So
to
next day also you will pray for adjournment.
No.
You will
Next
say
day after issuance of appointment letter, my client will join and I myself will submit before your lordship. Matter should be disposed of.
So commission has sent you where?
Yes, to Birati, right hand side school.
Mr. Vishwas Lanet, advocate appearing for Hey, listen, Mr. Vishwas. Hey, where is Mr. Vishwas?
Just about 13. Hey, 13.
We are keeping it on 19th.
19.
Join and come.
Obliged to your lordship. I also am praying for. Let it be joined. 19. Under that include. Grateful. Much obliged.
Yes, Mr. Mukherjee.
My lord, this is a report, my lord. That's it.
नहीं बोलो नहीं बोलो बोलो तो नहीं
কিছু লেখা কি আছে Yes, my lord.
A vacancy is not there.
My lord, vacancy is there, my lord,
Then
within the jurisdiction of the my lord DI of Kolkata, my lord. But my lord, 10C, my lord, the school education department has my lord transferred the on the 10C application, my lord. 10C.
Bypassing your lordship's order.
No, no, it is not the punishment transfer, my lord.
no, 10C order came later. First, he was recommended for transfer by the commission.
But it is for the proposal, my lord, not the my lord, not the transfer, my lord. Transfer will do it, my lord, the education department, my lord. My lord, kindly see the my lord. Page 2, my lord. The interest of the my lord, education, my lord, the transfer will make.
Page 45 of the DI order.
We will come to you. Wait now. What is 12th of March 2018 government order? Paragraph 9. Oh.
Paragraph 5.
Amendment.
পেন্সিটা এটা
নোটিফিকেশনের ডেটটা রাখো।
নোটিফিকেশন আছে পেজ 51
না ওটা টেন্সি কিন্তু এই নোটিফিকেশনটা জিজ্ঞেস করছেন এটা
ও নোটিফিকেশন
অলরাইট
লাইন
এই 12ই মার্চ 2018টা কি?
Yes, place your case. My brother was not there on the earlier occasion.
Page 44, my lord, the first my lordship kindly see the my lord's previous orders, my lord kindly see. What is the order passed by your lord, by your lordship, my lord, the kindly see.
We will see. You tell us the facts.
Yes, my lord, page 44.
You at last you tell what.
Yes, yes, page 44. Your lordship kindly see. That is the DI investigation report.
Yes.
My lord, I am not reading, my lord, entirely. My lord, prior to that, only page 45, third last paragraph. Your lordship, page 45. Therefore, in better academic interest, the teacher may kindly be transferred from Garden Ridge KC Mill High School to Adarsha Madhyamik Vidyalaya. This is the DI recommendation. The latter school is running with 1,250 students and 20 teachers, and the post of headmaster is vacant in 2022. Adarsha Madhyamik Vidyalaya is a boys' school, and the employee's ID, Alok Chaki, address of Adarsha Madhyamik Vidyalaya, such and such, is running with TIC since 2022. However, disciplinary proceeding may kindly be initiated against Alok Chaki. This is the, my lord, the DI investigation report.
So that amount of rupees 2,73,000, where it is written, it has been
27 lakhs.
That has been deposited also, my lord, today's report also. That is, my lord, the paragraph 8.
All right. Then what happened? Tell
now,
us.
after the report of
This
the
was
DI.
on 18th of July.
That is, my lord, 18th of July.
Then
next, your lordship, page 46. Secretary of the board on the, my lord, relying the DI's investigation.
After 1 week, about 1
After
week.
1 week.
Recommended
for transfer to the commissioner. Page 46.
Not recommend.
রেকমেন্ড কেন হবে কিন্তু এটা প্রিলিমিনারি ইনভেস্টিগেশন রিপোর্ট দিন
yes
so also can see page 46 in reference to the subject mentioned above, please find enclosed a photocopy of the memo dated just previous memo for your perusal and necessary action as deemed fit. The DI of school has recommended the transfer of the headmaster Sri Alok Chaki from Garden Ridge to Adarsha. This is the, my lord, the 29 July. My lord, after that, page 46A, Deputy Secretary of the School Education issued the letter addressed to the Chairman of the School Service Commission under Section 10C of the Amendment Act that from Garden Ridge to Sukchar Kedarnath Poddar High School, Barakpur. I don't know, keeping aside the board recommendation, DI recommendation, whatever. Now the on the based on the letter, page 47, Secretary of the Commission issued a recommendation, and page 48, my lord, the board issued a notification to requesting me to collect the transfer order. My lord, this has been challenged. My lord, they have sent through electronic mail, page 49. Transfer order has been sent to me. My lord, I have challenged, my lord, during the puja vacation, my lord, the school called a meeting for releasing me. My lord, entirely, my lord, the contrary to law, my lord, the contrary to the rule 16 of the management rules. During puja vacation, management committee cannot call the meeting. That is the subject matter not before the law. So, however, my lord, this order has been challenged before the learned single judge. My lord, learned single judge refused to pass an interim order. My lord, my submission was, my lord, last occasion also I have submitted. 10C Deputy Secretary, my lord, issued this, my lord, School Service Commission issued the recommendation for transfer to Sukchar Kedarnath under section 10C. That transfer order continuing the allegations against me as per the DI investigation report, not, my lord, the administrative reasons. My lord, that is why I proposes before your lordships, my lord, earlier occasion, that since the DI has recommended Adarso, I can accept Adarso. My lord, even, my lord, my challenge was, my lord, my transfer was illegal. But I can accept the Adarso. Because the Adarso, my lord, the nearest to my residence. Also, my lord, the DI has also proposes. That is why, my lords, my lord, the earlier division has also directed that whether the Adarso, why not, will not be transferred to Adarso. Now, my lord, the DI has submitted a report.
So why you are saying that it is not on administrative reason?
Page 10.
Page 47, School Service Commission. Because the
রেকমেন্ডেশনটা যেটা করলো, that was also for a reason.
বলতে চাইছিল অ্যালিগেশন সেম রাইট রিপোর্টে অ্যাজ পার রেকমেন্ডেশন হচ্ছে সেম রিপোর্টে ডিসিপ্লিনারি প্রসিডিংস জিজ্ঞেস করছি অর্ডার করে
এইটাতে অ্যালিগেশনটা হচ্ছে
তোমার ইনস্ট্রাকশন বলতে এটাই ডিফেন্ড করতে হবে, আমি যেখানে পাচ্ছি সেখানে যেতে হবে।
হ্যাঁ,
এই জন্য ফিনান্সিয়াল
অপশন
বললো যে ওকে ট্রান্সফার করে দেয়। What is the administrative? সেই জন্য ইন্ডিকেট থাকে টেন্সিটা তো নট রিস্টার্নিং ফার্স্ট
ইন্টারেস্ট অফ এডুকেশন
দেবেন।
there, and, my lord, initiate proceedings. That is why, my lord, I am relying the Supreme Court.
Why double punishment you are saying?
First of all, my lord, I have been transferred to somewhere, and next, my lord, the initiate proceedings.
Proceeding was not a punishment.
First of complete the proceedings.
Proceeding has you are saying by that recommendation, proceeding was asked to be initiated, and you were recommended to be transferred.
That is exactly, my lord, the Supreme Court says no. Punishment on the allegations is malice in law. So I can rely the judgment of the Honorable Supreme Court. That can't be.
Then what do you say about 10C?
10C, my lord, on administrative reasons, my lord, I have been transferred under section 10C. Lordship, my lord, why I have been transferred on administrative reasons.
Yes.
Based on allegation of the DI, not on administrative reasons. Your lordship kindly see, the first DI complaint, DI report has been submitted. Board has recommended me. Then the deputy secretary issued the order of the under section 10C. Now the secretary of the school service commission under section 10C. In continuous, arbitrarily, from the date of investigating, without any proceeding. Till date, 4 months elapsed. Till date, no proceedings, no charge sheet, no nothing. Let them suspend me if the investigation is hampered. I cannot be transferred. That is why, since there is, your lordship, I have also, handed over, the paper cutting. There is very difficult to discharge my duty. That is why I propose that I can accept, apart from the litigations and law, I can accept only others. That is why your lordship recorded that. Now the DI has bypassing your lordship's order. 2 pages, the several allegations and
no, he says that 10C order, I cannot do anything.
Yes.
That is his
No,
content.
my lord proposes that why that others of the DI himself recommended me for transfer to others. Whether the vacancy is lying in others or not. They did not disclose whether the vacancy is lying or not. DI himself said there is a vacancy. Why not others of? That is why the shortcut the others of, what is their problem?
London is taking 2 stands. Either he.
That's true. That is 2 stand. This is your lordship's It
is the difficulty.
Deputy Secretary orderটাতে কোনো এনসি ও প্রভাবিত হতে কিভাবে এটা আসলে হলো আছে পাস করতে গিয়ে তো ওই পিআইআর অর্ডারটাও দেখেছে যদি অ্যাডমিনিস্ট্রেটিভ হিসেবে ট্রান্সফার দ্যাটস খুবই চাইছে কিন্তু এইখানে তুমি বলছো খোঁজ বলছো না Now, how far is this school Shukchar from your present school?
About 32 kilometers. And the 46 page, board has recommended to Adarso address to the Commissioner of School Education.
Board has not.
Now the Commissioner of School Education address to the Commissioner.
Board has nothing to do.
Board is.
Are Baba. Board has recommended.
Not
recommended.
Please, if you repeat it, why you are saying at the wrong time, you will get your touch. If you may speak in between, we get disturbed. Have mercy on us. We are doing so many matters.
Well, the page 46, board has recommended for transfer me to Adarso address to the Commissioner of School Education.
Intimation.
Page 46.
46. 46 is an intimation to the commissioner.
What about the address to commissioner? Next page, deputy secretary, same office, deputy secretary of the school education department.
Same office?
Yes, commissioner of school education, deputy secretary has recommended to Shukchar. What is their intention? I have challenged very well. I have challenged the transfer order of Shukchar. I have challenged under section 10C, why the transfer me, on administrative reasons. On the allegations, on the basis of the report of the DI, this transfer order also issued against me, not on administrative reasons. That is, on the report, on the basis of the based on report of the DI.
What is an administrative reason?
No, here also can you see also, the administrative reason. Page, I have annexed the page 51 10C. 10C, the Amendment Act I have annexed. The page 51, last paragraph. Notwithstanding anything contained in any other law for the time being in force or in any contract to contrary, the state government in the interest of education or interest of the public service for administrative reason may direct the commission through guideline or general instruction. Where is the guideline?
That is the government order which he has referred to in this.
No, that Your Lordship, where is the referred to?
Paragraph 10.
2018?
No.
Yes, I have seen that 12 March 2018.
Yes.
Where is the comment?
এটা কোথায়? এটাই 12 মার্চ।
পাইনি, এটা যে দিয়েছে আমাকে, যা দিয়েছে আমি এটা দিলাম। 12/3/2018
নম্বর এত ডিপার্টমেন্ট এডুকেশন
for the interest of the education, এটা তাই বলেছে।
এইটা দেখো
পাবলিক সার্ভিস অ্যাডমিনিস্ট্রেশন।
How your DI says so? Please understand. The first DI's recommendation was initiate proceeding and you transfer him to that school considering the role strength and teacher population of that school. After that order was passed on 16th of, that order was passed on 18th of July. Now after about a week, in July itself, the board intimates this to the commission.
Board intimates.
Next, after 2 months, you take a decision that on 10C, he will go and get transferred in another school. This prima facie, Mr. Mukherjee, what is the reason for issuance of this memo? There is no other reason. For administrative reason, you can. He must not be kept in that school. That was your idea. So if that is your idea, and when the vacancy at Adorsho is vacant, you are saying that no. Even if done, we will not take him to Adorsho. Then we will set aside your deputy secretary order.
Yeah, you will recommend within the jurisdiction of the Adorsho Mahavidyalaya, my lord.
That is the DI has said.
He has said. That recommendation, my lord, submitted before the, my lord, board.
Yes.
Board on the, my lord, preliminary investigation report, my lord, to submit the, my lord, Commission of School Education, my lord.
Yes.
On the, my lord, paragraph 10, in the interest of education and, my lord, the interest of public service of administrative.
Mr. Mukherjee, I cannot change my reasons. When I issue the first order, your deputy secretary sleeps over 2 months. It is not that your government does not know. He issues the order under 10C after 2 months. See, order was 29th of July. Your deputy secretary suddenly wakes up and says that no, 10C I will apply, you go to another school.
18 সাথে ডিআই লিখেছে, 29 সাথে বোর্ড পাঠিয়েছে, আর ডেপুটি সেক্রেটারি ইস্যু করেছে 16 সেপ্টেম্বর। তাই পাঠিয়েছে সেপ্টেম্বরে করেছে, সেটা তো কি
for the interest.
Now, what is the, after this order was passed, what is the board's observation? Come to page 49.
49.
Page 49 টা দেখো, এবার ওই 10C order হলো তো, এবার board page 49.
Well, this is a printed form.
It is a printed.
At that point of time.
Wait, the West Bengal Commission has forwarded recommendation on 9 September 25 for transfer of following teacher in pursuance of the direction received by them from Department of School Education. Vide memo dated 6th of September. This is September, 16th of September. That is page 46. Now let us stop here. For rationalization of subject teacher in terms of notification of 10th February. This is a new ground he is taking. This is not 10C application.
No, no.
That's
That,
the mistake.
that is the mistake one in the printed
Now
form.
transfer in exercise of power.
Beautiful.
Board of Secondary Education appointment confirmation conduct and discipline of
সেটা হচ্ছে রুল 3 আসুন
Well, at that point of
যা
time,
যা যা ওয়েট
type of form.
রুল 3 আসুন রুল 3টা হচ্ছে পেজ 52 53 পেজ 53 এরপরে পরের পাতাটা পরের
Recommended transfer.
ও এই যে রুল 3
এই ক্লজ
তোমার একদম
10ই ফেব্রুয়ারি 23
পরের প্যারাগ্রাফ
এই যে রুল 3 তে দেখাচ্ছে রিভিউ রেকমেন্ডেশন
অন্য
রেকমেন্ডেশন ডেপুটি সেক্রেটারি
খুব চালাক
Unless friends, client, my lord, will accept the, my lord, DI proposal, DI recommendation, the Adarso, my lord, why he will not go to the Sukchar, my lord, some distance are there, my lord.
Why? Today you are saying, today you are telling me be at place X. After 2 months, you take a decision. No. X is not. You have to go to Y. You are sending the
Alright,
teacher from. Your purpose is to remove him from the school. Remove him
For the interest of student, my lord.
for the interest of the
Education.
students. And we have asked you that why.
That's why, my lord, school education department, my lord, will issue the 10C recommendation.
Pardon?
For the interest of education, 10C.
For the interest of education, when you are sending him to another school, your interest of education is fulfilled. Why you are throwing him to another school? Your deputy secretary, after 2 months, takes a decision that no. That he must have said that Adorsho is not will. Adorsho, there is no vacancy or there is nothing. That is not the case. When you are exercising 10C, 10C was open to you after the DI passed the order. You could have said that DI order is not approval. We are in 10C changing into administrating. This is another cause you are changing. It becomes prima facie penal in nature. Yes, and what is your submission, madam?
My submission is that the board issued the transfer order, my lord. At that point of time, there were two. One 10C transfer was issued, and another, my lord, a rationalization was issued. That was introduced by the state government education department. At that point of time, the transfer was done in 2 ways: one by 10C, one rationalization. So, my lord, this format, I think that format has issued in that. It should have been in 10C because there are 2 formats. This has been done wrongly. But other way, I don't have any submission because it is upon the state government to decide where to transfer, whom to transfer. Board only issues transfer order on basis of recommendation. But though it is upon the state to, they are subject to lordship, but your lordship, the DI does not have, DI can recommend for the interest of the institution for transfer, but DI cannot take the name of a school. That is only about the
order. Then in the order, it should have been stated
lordship.
Unless the DI order was there, why the deputy secretary will issue the order? Why the deputy secretary issue a fresh order applying 10C? You cannot simply send him to that school.
No, my lord, my submission is that DI is looks after the regular running of a school. So, my lord, if a DI finds that presence of this particular person is hampering the institution, my lord, he can always recommend to transfer the person. So, my lord, but to take a name of the school, DI is not the authority to decide on the name of the school. DI can just simply forward to the education department and recommend for transfer. And it is the education commissioner of school education who has the power to decide the person to be transferred in which school under 10C. That is my only submission. So, I mean, taking the name of the DI is my land is overact on behalf of DI. That is only my understanding.
Till now, others is
DI কোনো নাম নিতেই পারে না।
না পারে না তো।
সেটা তুমি বলছো না তো, তোমার মক্কেল, আমি বলছি।
ও বলেছে আর আমি সেটা ডিনাই করি।
এই দুটিটাতে একটা লাইনও লেখেনি আদর্শ সাথে যোগাযোগ
কেন লিখ
করে।
আরে ডিআই সাথে কনসাল্ট দিয়ে তো
ডিআই তো কমপ্লাই করি।
ভেবেছিলাম মিটিয়ে দেবো। Your deputy secretary, you had a talk?
Yes, ma'am. No, my lord. Only to DI.
We don't find, Mr. Mukherjee, why you are not sticking to Adarsh. Your deputy secretary gives no reason. That is why we requested you. Why will you suffer an order of setting aside of the order?
Adarsh is still vacant, my lord.
Then why
further, my lord, I filed for further. Deputy Secretary, Education Department.
So we gave you 7 days time, Mr. Mukherjee. There is a commotion going on.
Only
DI Kolkata.
আজকে বৃহস্পতিবার সোমবার এসো।
He can obtain instruction.
How many days we will?
Only.
You talk to your deputy secretary and say that send him to Adarsh. Problem solved. Otherwise, suppose after if we pass a judicial order, then in future your deputy secretary will be in problem. We do not interfere in transfer matter, but in this sort of a case, when there is a vacancy, where there is a commotion in his school, you send him to other school, and she will initiate disciplinary proceedings.
Understand.
And page 45, deputy secretary was communicated. DI communicated for others, transfer for others.
কোথায়?
Yes, page 45 address to deputy director. That is the all officers are sitting in the Vikas Bhavan, Commissioner of School Education. You will also page 45 address to the deputy director of school education.
Let us solve the problem, Mr. Jan.
That I have no problem. That is why
from
beginning I Monday goes to school. Half an hour he can take instruction. Vikas Bhavan over telephone.
The same order you want. In one hand you are making recommendation of transfer. In the same order you are saying the disciplinary proceeding may be initiated.
That was a preliminary inquiry report. It is about the board to initiate proceedings.
Problem would not have been there had he not said that you
name of the school. No, name of the school. Name of the school.
Your jurisdiction of DI is to decide whether disciplinary proceeding has to. He has no right to transfer the person or recommend. No. Had that paragraph been not there, very good. No. Your deputy secretary could have said that order 10C. We wouldn't have interfered.
Monday, I'll talk to Malak.
To be mentioned Monday. No, Monday you have to bring your DI has to. Your DI cannot do anything. No. Your deputy secretary who issued that order, he is to do. That you come with an order placing with a recommendation to the board that send him to Adarsh, which earlier was issued.
Gosh.
But my lord, as per the procedure followed, my lord.
Order may be passed, your lordship.
Order so that I can also communicate to the deputy.
May I ask
your lordship, my lord?
Whether court can ask anyone to send to a particular school.
Yes, order, my lord, it is indicated.
My lord,
transparency of the investigation. I think that.
My lord, the final recommendation, my lord. That has also been issued by the
nothing to say why you are booking your.
I cannot on the
NC
you went for
managing committee. NC has been applied, my lord, just to.
How? What is your problem, sir, if he goes to Adorsha?
I do not have problem, my lord.
You will throw him out of the school and you will again dictate that send him there?
My lord, they told that I have passed the, take the resolution.
So you should keep quiet. We are not setting aside. We are saying that you have to go to Adorsha. Are we are trying to have assistance from you. You are taking points. Ask your deputy secretary. If he doesn't, if he is so adamant, then we will appropriately deal with the deputy secretary.
Well, then an order may be passed to your lordship, directing the deputy secretary, your lordship.
That order is already there.
আজ এতক্ষণ আর্গুমেন্ট করলে এটা অর্ডার হবে না
By an order dated, by an order dated 31st October 2023, we asked Mr. Mukherjee, learned advocate, এইটা কি গো এখানে দিয়েছো আমার four. You're there, Mr. Jana, Mr. Jana.
Physical education, our pay scale, earlier your lordship had the matter when just Mitro, that matter.
But my matter is completely different.
Chotto.
No, not Melody, already Melody.
No, Mr. Chattopadhyay, is it covered by Justice?
No.
Because
No.
Justice, the special bench judgment, nothing has been said regarding the physical education. Earlier, Boishali Banerjee, and that has been referred. But what is the conclusion of the special bench?
No, my lord, may I?
Here it is a bit different.
May I tell you, lordship,
Yes,
only 2 points. My lord, the short point. GI has, my lord, initially allowed me.
Just a moment.
Baba. No, I don't understand.
Katti, এইটা দেখো তো এই can
The page 69, initially in compliance of the order of the Honorable Division Bench, DI has allowed higher scale of pay for my MPA, page 69.
Yes.
But they have, at the same time, they have filed an application for recalling of the order of the Honorable Division.
Page
69.
No, you argue the matter because my lord did
Yes,
not.
that is why, my lord, I am placing that. My lord, I have, my lord, handed over a list of date with some certain enclosure.
List of dates?
Yes. List of date I have given, my lord, with certain enclosure, my lord, which have not been annexed. That's what. Check.
এটা কোন
দিয়েছি আগে দিন দিয়েছি I, just melody, I joined in 1991 in the science and mathematics group. The proposal was made to the DI for shifting to the social science group, since I have a qualification of BPA. The DI has allowed. That the DI sanction order I have annexed in my list of date. And after that, I enhanced my qualification.
No, you had approved as a teacher in science group.
Science group.
Show us from the stay application, page 50.
Page science group.
BSc.
Page to 49.
BSc with diploma in physical education.
BSc degree, but this is the
diploma in physical education.
Diploma in physical education, but I was probably this has not been, sanction order has not been annexed. You will also can see list of date first annex here.
First annex. This is 26 September 1996.
Yes, I have been shifted to social science, physical education group.
26, yes, shifted to physical education.
Now thereafter, my lord, I enhanced my qualification MPA, that is 2000. Yes, last date of examination 17 July 2000.
17 June.
17 June 2000. Therefore, I approach the, since no action was taken, approach this court, this on a single.
No action was taken for what? That for
postgraduate scale up, higher scale up. I approached the authority for granting higher scale up.
Then you approached the
single bench dismiss my writ petition. That is, my lord, I preferred an appeal, intra-court appeal.
Dismiss the representation, dismissed on what ground?
Dismiss the representation in view of the Control of Expenditure Act.
Page 61.
Page 61. Right, you will also get to you. That has been only in view of the Control of Expenditure Act. I am not entitled.
Very good. Then you
preferred page 66. I preferred an appeal. Division may said that in view of the judgment of Souvik Ghosh, the mandatory order was passed to sanction the benefit of higher scale of the page 67, second last paragraph.
Very good. Then
now the page 69, DI had sanctioned the postgraduate scale of pay subject to the final judgment of recalling filed by the state government CAN number on recording of the order of the Honorable Division. Sanction postgraduate scale. But recalling application was not listed for several years. Ultimately, I moved a writ petition for...
No, contempt you preferred.
I contempt preferred. Contempt has been dismissed. The contempt has been dismissed as the higher scale has been allowed. You will also see the contempt order, page 70, 70. 70. In view of compliance, nothing survives for decision on this contempt application. Even then, no benefit has been given to me. I again moved a writ petition only for getting benefit, not for granting higher scale of pay.
So your writ petition was
page 77.
Page 77.
77. This single bench directed that to grant the benefit in terms of the sanction order.
No, I come to page 81.
No, before that, page 78 and 79.
DI 79, he says
to grant the benefit of higher scale of pay as per the order dated.
Now, needless to say, all arrear payment also need to be paid within a year.
Yes.
Still on behalf of the division has undertaken to has undertaken to refund the additional benefit arising out of in the event the order is recalled.
Yes. Recalled or over modified. This is the similar.
Then
now
what
the
happened?
state has preferred an appeal against this order.
State preferred an appeal. So that appeal was heard along with the recalling appeal.
Recalling appeal. Recalling application was dismissed.
No, no. Before you go to that, Mr. Jana, please tell one query. Page earlier order.
Earlier
page
division?
68. Page 68.
60.
67.
67. Yes.
DI was directed to give you grant scale.
Yes.
Now, needless to mention, petition will be entitled to receive payment from the date following the date of exam is deemed to be done. Now, this was passed placing reliance upon Shobhik Ghosh.
Shobhik Ghosh.
That is prospective nature of control of expenditure, right? Not physical education.
Not physical education.
Achha. Now,
that is why they filed an application for recalling. Shobhik Ghosh note is not applicable to me. Recalling applications. The state has filed an.
No, why they will say Shobhik Ghosh is not applicable?
Because probably Shobhik Ghosh is not a physical education teacher. Whatever matter this Shobhik Ghosh.
Acha, then now place this is the final order passed.
This is the final order.
Page 80.
Page 80. No, recalling after the recalling application was dismissed, page 80, and appeal was heard, page 82.
No, page 81, please read.
Page 81, considering the fact.
In the present appeal.
In the present appeal before us, namely Madam Such, the issue is whether the provisions of 2005 Act would be applicable to the writ petitioner in view of its improvement in qualification before the said Act came into force. Although the learned coordinate bench has referred to paragraph 14 of Shobhik Ghosh, but the learned division bench has also come to a finding that the said Act has no manner of application. It is not solely dependent upon Shobhik Ghosh, although reference was made to the said decision.
Why it is said?
Why should that probably, my lord, the Shobhik Ghosh
not solely dependent upon Shobhik Ghosh.
Shobhik Ghosh, my lord, the
Shobhik Ghosh
enhanced his qualification.
Brought Shobhik Ghosh. আনতে হবে
Shobhik Ghosh
তুমি নিয়ে আসবে না Shobhik Ghoshের সাইটেশন কত
Shobhik Ghosh পাঁচটা কেন নিয়ে আসেনি কে
এই আনাও তো 2008 ভলিউম 1 সিএলজে একটু লাইব্রেরিতে পাঠাও You send your clerk na 2008 volume 1 CLJ Calcutta page 810 Shobhik Ghosh
পুরো বাঁচটাই তো নিয়ে আসছি
2008 volume 1 ও তুমি পেয়ে যাচ্ছ
দেখছি আছে কিনা
You have Acha please check up whether it is physical education. It is not pertaining to retrospective control of expenditure act. কি বলেছে ওটা What was said?
After the control of expenditure.
Justice Indira Banerjee. কি বলেছিল তারপর What did the court say? Give the benefit.
In Shobhik and Vishal is on the same book. In respect of.
Is it 3 judges bench or?
It was referred to the
larger bench of?
Of Justice General, so mention of and
what was decided? Physical education?
Physical education. See, Vaishali was upheld in paragraph and he preferred an application following the Vaishali. Therefore, physical education is that they are just separate. You can see the Vaishali in everything. And pursuant to the Vaishali,
পাঁচটা নিয়ে না এটা
other honorable to pass the order. Following the order. DI commissioner also complied with those orders. in respect of the
সামনের
Commissioner of Education concept
পিছনে অনেকগুলো জাজমেন্ট পরপর
that is the
অনেকগুলো
latest
কম্পারিজন করা আছে
position.
তার উপরে স্টপেট করা আছে
No,
সৌভিক ঘোষ আছে
Accepted the view of the last.
সৌভিক ঘোষ আছে দেখুন
what did the physical education differences pertaining to entry into service? If it is physical education entry, there was a 93 circular. One was a Nagpur course, whether it is full time or half time. On
summer course.
Summer.
From Nagpur.
Ultimately, for physical education, staff pattern was removed and said that even if Nagpur summer course, you will have to give it. That clarification, government tried to stop that. So government issued a clarification note, which was prospective in nature. 9th March 2000.
My lord,
it is an appeal, division bench appeal, Justice.
Justice Standard division bench. And in one of the matters, the lordship, Justice Standard.
ওটা জয়ন্ত বিশ্বাস সেটাতে দুটো ডাইভার্জেন্ট ভিউ দিল সৌভিক ঘোষ এক কথা বললো আবার জাস্টিস নির্ঝর সিটিং উইথ জয়ন্ত বিশ্বাস আরেক কথা বলল এটা ইন্দিরা এ ফেভারে হোল্ড আর জয়ন্ত বিশ্বাস বসে কন্ট্রারি তারেক চন্দ্র then what happened it went to larger bench then larger bench said
according to the notification from 1998 as well as 1999, all the circulars to be prevail on that date as the
but prevail on which date?
From 1998 and so far as physical education teacher, since there is no entry in the honorable procedure, having the postgraduate degree, they are entitled. If you are paragraph 10 of Boishali, that has been upheld by the government, I put before on behalf of Boishali for the larger.
My lord, I have given the judgment of Boishali. আগের দিন সব দিয়েছিলাম পাট করে
কিছু দেয়নি আগের দিন দিয়েছি আগের থেকে চেক দ্য
Yes, I have given my lord the my lord judgment সব দিয়েছি আর কিছু ফাইল নেই
দেখো না একটু বের করে দাও দেখি একটু বৈশাখীটা দাও তো একটু
দিয়েছি বৈশালী আর ওখানে দিয়েছি আগের দিন আগে হ্যাঁ I have given your lord to your lord দিয়েছি
one copy
two copy always I have given
আমি চেম্বারে নিয়ে চলে যাইনি তো
appointed in 2004, but the person 2004 postgraduate, they are just after joining, but by prior to contact.
But I think that issues are not involved here.
No.
I think that is not involved here.
This issue, my lord, is involved in the Boishali. That is, my lord, upheld by the single bench in my case.
Now give us the order of the DI.
Now, my lord,
tell us
that
after the
order of the DI.
After the Justice Sharaf's order,
they preferred an appeal.
No approval was given.
Yes. This appeal, my lord, the page.
Now, prior to the DI order, prior to that.
That is the first appeal. Now, the second appeal, page 80.
First appeal, they sanctioned, page 69.
Page 66.
Object to the result, they sanctioned.
Thereafter, my lord, no benefit was given.
My lord, I preferred read court also said subject to you give. Now the recalling along with the appeal.
Recalling, another appeal has been filed. That appeal has been disposed of, previous appeal. Now another appeal has been filed.
Which was hard with can 5.
Hard with can.
And now you place that order.
Page 80. 80 is not relevant because can has been dismissed. Now 82. This is the final order of the appeal.
First place 81. First
Page-
place 81.
Page, start from page.
First place 81. Recalling application which was decided.
Recalling application.
Read in the
In the
present.
present appeal before us, namely MAT 1455, 1455 2018. That is, my lord, against the order of Justice Saraf. The issue is to whether the provisions of 2005 Act would be applicable to the writ petitioner in view of his improvement qualification before the said Act came into force. Although the learned coordinate bench has referred to paragraph 14 of Souvik Ghosh, but the learned division bench has also come to a finding that the said Act has no manner of application. It is not solely dependent upon Souvik Ghosh, although reference was made to the said decision. Considering the facts that the issue that need to be decided is not covered by Souvik Ghosh, there is no reason to revisit the order passed by the learned coordinate bench dated 20th September 2012.
Now
accordingly can stand dismissed. Next, now the appeal has been finally heard. Lord, may I read it, my lord? The appeal is arising out of an order dated 6 July 2018, whereby the district inspector schools was directed to immediately grant the benefit of higher scale of pay to the writ petitioner, as per the order dated September 28, 2012, in view of acquiring qualification of Master of Physical Education by the writ petitioner while working in the post of assistant teacher in work education and physical education group. The case of the writ petitioner as made out before the court of law was that he was an approved assistant teacher appointed on 11 November 1991 in work education and physical education group, having qualification of BSc and BPA. Subsequently, the writ petitioner acquired postgraduate qualification in physical education, merely Master of Physical Education, namely Master of Physical Education from the University of Nagpur in the year 2000. It was also the case of the writ petitioner that the last date of MPA examination was 17 June 2000. After acquiring postgraduate qualification, the writ petitioner approached the concerned respondent authority for extending the benefit of postgraduate scale of pay in his favor, since he was possessing higher qualification relevant subject. The District Inspector School AC Kolkata, by issuing order dated 16 June 2007, held that writ petitioner was entitled to receive the benefit of higher scale of pay from the day following the last date of examination was subject to the final judgment to be passed by on recalling application filed by the state. We have already considered the relevant application being can number such and such along with the appeal, which have been prepared by the state authority appellates questioning the impugn order dated 6 July 2018. While keeping the appeal pending, we dismiss the recalling application by order dated 20th September 2019. And on previous occasion, we directed the appeal to be heard on 13 January 2020. We further directed that the concerned authority of Basudepur High School to cooperate with the state authority or appellant so that the staff pattern of the said school can be placed before this court for considering the claim of the writ petitioner in the matter extending the benefit of postgraduate scale of pay. Today, the staff pattern has been placed before us, wherefrom it appears that 3 teachers were working under work education, physical education group in the said school. Name of the writ petitioner respondent Pradeep Kumar Biswas featured at serial number 2 of the staff pattern under the relevant group of work education or physical education. During the course of submission, it has been contended by the learned advocate of the writ petitioner respondent that another assistant teacher, namely Pradeep Biswas, worked under the said group of work education, has died in the meantime. And third teacher, namely Pradeep Mitra Mujumdar, has also been shifted from work education to another group. Therefore, it is submitted on behalf of the writ petitioner respondent that he should have been considered as the sole teacher under the work education physical education group. As such, the writ petitioner was entitled to receive the benefit of postgraduate scale of pay as per staff pattern. Meanwhile, the writ petitioner respondent, namely Pradeep Kumar Biswas, has superannuated and all retirement benefits have already been paid to him, considering the scale of pay which he was enjoying on the last date of his service. While examining the right of the writ petitioner respondent to get the benefit of postgraduate scale of pay for acquiring higher qualification, we find it opposite to quote amended subparagraph 3 under paragraph 12 of ROPA 98, which was brought into the effect notification dated 13 July 1999. I have bonds also, I have given to your lordships.
কি বলছেন বুঝতে কোন
ROPA 98 and others amendment.
Okay, 12.3 of ROPA 98.
And my lord, the page 85. On mere reading of the amendment of paragraph 12, subparagraph 3, it appears to us for extending the benefit of higher scale of pay, staff pattern of the school is a relevant consideration which escapes the consideration of the concerned state authorities as well as the learned single judge while deciding the writ petition filed by the writ petitioner hearing. Since the District Inspector of Schools AC Kolkata is the appropriate authority to consider the claim of the writ petitioner relating to postgraduate scale of pay upon considering the position of the staff pattern which was subsisting at the material point of time in the said school, we find it opposite to remand the issue back to the concerned district inspector schools for consideration upon taking note of the relevant provisions as contemplated under paragraph 12, subparagraph 3, read with amended provisions which was introduced by notification dated 13 July 1919 as quoted above. Accordingly, we direct the DI to pass a reason order relating to entitlement of the writ petitioner respondent to get higher scale of pay for acquiring postgraduate qualification in the physical education after giving an opportunity of hearing to the writ petitioner who is a retired assistant teacher of the said school as well as the said school authority which shall place the staff pattern including other relevant documents in support of the claim of the writ petitioner. While deciding the claim of the writ petitioner relating to extending the benefit of higher scale of pay, the District Inspector of Schools shall take into consideration memo dated 4th September 1998 that is the staff pattern. The aforesaid exercise shall be completed within a period of 8 weeks from the date of communication of this order. We make it clear that in view of earlier order dated 20th December 2019, in disposing can, it would not be open to the DI to deny the claim of the writ petitioner on the basis of the decision of Soubik Ghosh. Well, this is the order of the Honorable Division. Now the DI has passed a reason order, page 92. The DI, paragraph 2, DI has categorically stated, you will also can see paragraph 2. It has been found in the staff pattern of that period of school, the assistant teacher were working, page 92. 92, this is the impugn order in the writ petition. It has been found in the staff pattern of the period of the school that 3 assistant teachers were working in work education and physical education group. Pradeep Kumar Biswas was the second assistant teacher, serial number 2. This staff pattern I have annexed in my list of names. Group. Pradeep Biswas was the first approved assistant teacher of the aforesaid group with effect from 1985 and died on 15 December 2013. Pradeep Mitra Mojumdar was the third approved assistant teacher. He has been shifted to social science group. So now this Pradeep Kumar Biswas alone in the group of physical education and work education. No, he retired. That is the earlier division also observed that he retired on supervision. He got the
getting pension?
Got the benefit on the basis of postgraduate scale of pay.
As by the
postgraduate scale of pay.
When did you retire?
Retired 30th April 2019. 30 April 2019.
Now come to DI's order, page 9.
Next, next page 93. The staff pattern has been quoted. You will also can see last third, fourth paragraph. As per GO number 670 AC dated 4th September 1998, that is the staff pattern also I have annexed in the compilation. And GO number 14 dated 8 March 1998, that is the 14 March 1998 I have also annexed. That is the qualification for School Service Commission to distribute for selection. That is what is the qualification of physical education. That is the prescribed in the notification, 8 March 1998, that I have annexed. The qualification of 2 assistant teachers in work education and physical education group must be bachelor degree with degree diploma in work education and physical education. In the present case, at the material point of time, the petitioner was the second teacher of the aforesaid group. As per staff pattern and graduate scale of pay is admissible in favor of the petitioner. Nobody was never, my lord, getting a postgraduate scale of pay. Nobody was. Never, my lord, because of the staff pattern, my lord, none of the three teachers was getting postgraduate scale of pay. All of them bachelor. Only petitioners acquired, my lord, MPA. Now next paragraph. As per GO number 670 dated 4th September 1998, that is staff pattern, and 14 AC dated 8 January 1998.
What is this? 8 January 98?
8 January 1998, that is that is 8 January. Oh, that is, my lord, my lord, acquired the qualification from Nagpur University in summer course. That is not permissible. That has already been held.
That circular is here.
Circular, yes. I have annexed, my lord, the 18 March.
8 January 98.
90.
You have got 8 March 2000.
8, no, that is also I have annexed.
That you have annexed. 8 January 28 টা কোথায়?
No, that is করেছি 8 March 14 টা করেছি এটা কোথায়? No. 14 January I have annexed. Yes, 14 January I have also annexed. 14 ACB 8 January 1998. That is the procedure for selection conducted by the School Service Commission. There is a qualification prescribed. That I have annexed in my list of dates.
Then why he is saying the qualification must be bachelor and sergeant? In the present matter, petitioner was the second teacher as first tribunal. Then he comes within the fold.
The list of details.
That is the wrong. That has been wrong, my lord, the interpretation by the DI.
It is qualification.
And your lordship can see DI, my lord, the finding, my lord, the show 155 dated 13 July 99 is not applicable in favor of the petitioner. My lord, even assuming that 13 July not applicable, because DI also saying that the 13 July 99 amendment of ROPA 98, 13 July 1999, qualification prescribed on the recommendation. That is, but I was not recommended by the school. I was not recommended by the school. That is why DI said that the 13 July is not applicable. Very well.
Is not applicable.
Pradip Biswas petitioner passed MPA in 2000 was held in June in vacation scope from Nagpur University. As per GO number such and such, the postgraduate scale of pay is not admissible in favor of the petitioner as he has not obtained such degree from 2 years regular course. This has been set aside by the learned single judge in my case. The state has not preferred an appeal.
Where?
So that I am coming to that, my order. Now
this matter. Not in this
matter. In this matter.
Achha, sure.
Page 94, show the order dated as per GO, no vocational MPA has been allowed, higher scale of pay, since it is not a regular course. My lord, also, my lord, the sitting singly, my lord, the passed an order. I have a copy, I have given also, my lord. Now, your lordship, my lord, the single bench of that order. That is page
98.
Page 128.
You preferred this writ petition challenging the DI order?
Writ petition? Writ petition was disposed of. 2 grounds. One grounds, my lord, from Nagpur University, I acquired the postgraduate degree. Another ground, my lord, the staff pattern or my lord, the qualifications for selection of physical education is only bachelor degree. That is the 2 grounds they have stated.
Page 130, kindly come. Whether GO of 8th March 2000 can be a bar. 8th March 2000 is a memo of?
Memo of, my lord, the course from the Nagpur University. That I have annexed.
You have annexed. Yes.
8 March. That is also, my lord, the settled by your lordships. Another, my lord, the coordinate bill I have given also last of that. I have a copy.
So what did the court hold?
Now the single judge, my lord, the page 132, 12, paragraph 12, in view thereof, the court is of the considered view that the matter should be regulated to the DI to decide the issue as to whether the approved staff pattern of the concerned schools permit the extending the benefit of higher scale of. Well, the staff pattern in one hand is not applicable, and also in another hand, I submit that the
staff pattern not applicable. That is which circular?
670 4th September 1998. That is the, my lord.
Yes, you have given. Where is
Yes.
that again?
4th September. That is, my lord, the
4th September, where it is said that staff pattern will not be applicable in
my lord, have 4th September, this compilation, my lord, I have given.
Yes, yes.
4th September, that is page 10, 110. Yes.
Where it is said it will not apply to physical.
You will also kindly see paragraph 2 for high school. D. Work education, physical education, social science. 2 posts. Other category A, B, C. 2 posts within bracket, 1 pass degree, 1 honors degree. Language group, science group, social science group. Only in respect of work education, 2 posts. There is no segregation.
What is this 8198? 8198 is the
8198. This is the procedure of selection of the School Service Commission. That I have annexed, my lord, in my list of 8198. That is
so
the
you have that qualification.
I have. That is qualification prescribed for bachelor degree. That is I said, my lord, why the postgraduate scale of pay will be.
Now, why you are saying then staff pattern is not applicable in respect of?
In respect of, my lord, the 2OA. First of all, my lord, according, even staff pattern apply, I am entitled. Nobody.
Right.
If staff pattern apply, my lord, not apply, because, my lord, page 10, that is covered by the judgment of Boishali Banerjee, that has been upheld by the larger bench. That only in the case of work education and physical education.
Where page 10 what you are showing?
That is my lord, the staff pattern, 4th September 1998. That is, my lord, the serial number 2.
Yes.
2D. Work education and physical education and
there have been 2 posts.
2 posts.
As per the qualification of 98 memo.
98 memo, my lord.
Then why you are saying staff pattern not applicable?
Not applicable. There is no difference for past graduate or postgraduate or honors graduate.
This was said in Boishali.
Boishali, exactly, my lord, entire my lord, discussion was made. You will also kindly see Boishali. May I read it? My lord, the applicant was a postgraduate degree holder in physical education. She was selected for the post of physical education through the regular recruitment process conducted by the School Service Commission. After that stage, her postgraduate result was yet to be published. She was recommended to such and such school as physical education teacher as a past graduate. After declaration.
But this is concerning School Service Commission entry.
88, but the staff pattern, School Service Commission recommended on past graduate degree. She acquired master degree subsequent thereto. Boishali division means held that.
Boishali is in respect of persons who are entering after Commission Act 97.
I also, my lord, after the Commission Act, my lord, not through School Service Commission, but I was shifted in 2000. That is not the Boishali. What is the exactly, my lord, interpretation? Paragraph, your lordship will find paragraph 8. The case in hand is, however, having a silent feature. The applicant is a physical education teacher. There is no honors course taught by any of the universities in the state. Hence, there could be no such category in the School Service Commission in the concerned subject. Because the School Service Commission also advertisement, there is no category. We also do not find any such distinction being made in the physical education by the School Service Commission. Hence, all candidates who are having appropriate qualification in physical education are considered in one category. This is the 4th September 98, my lord. Others, my lord, two category. Physical education in one category. That is the pass category. If that be the position, their subsequent acquisition of postgraduate qualification cannot be equated with any other subject. This is, my lord, I acquired postgraduate qualifications on BPEd. I am a teacher of physical education.
Acha, what is 24th June 97 circular, which I decided in this matter?
24th June 97 circular, that is, 24th June 97. That is, my lord, the true correspondence course. I have anybody, my lord, the acquired postgraduate through correspondence. Permission is to be required from the
DI.
That is not applicable here.
That is set aside also.
Set aside also, my lord, that is not applicable because that application relates to recognition of the university, not the relating to. That is the division bench also held that, my lords also. And now the learned single by has remand up again, consider the staff pattern. Only that is the issue.
কোনো জায়গায় না অলরেডি ডিসাইড ও নিজেই আগের অর্ডারটাতে বলছে যে স্টাফ প্যাটার্নে ও আওতায় চলে আসছে, জনের মধ্যে চলে আসছে। ইয়েস মিস্টার চট্টোপাধ্যায়।
হ্যাঁ, আর কি না দিয়ে দিন তো, দিয়ে দিন কিছুই পাবে না। লার্জার বেঞ্চ খুঁজেছি,
লার্জার বেঞ্চ ছাড়া কি যাবি আর কোথাও এখন? কারণ তো লার্জার বেঞ্চই আমাদের সব। ফুটবল কান্তি At best, at this stage, my lord, the special bench judgment is prevailing, and that is binding upon us regarding higher pay scale. My lord, your lordship, Tarak Chandra Koron, Roy. That is the, my lord, physical education, higher qualification, that will settle up to Supreme Court. This is not entitled. Now, your lordship has the larger bench judgment. I have only one copy.
Which one?
Utpal Kanti Gordon. Larger bench.
Utpal Kanti, yes.
I have only one copy. Can I hand over?
No, but how your argument is...
on the view of the larger bench. Nothing more.
Larger bench said what? Tell us.
Larger bench upheld the Tarak Chandra Koron. Sorry, Tarak Chandra Rai. No other, nothing. Only 2-3 paragraphs in my lordship.
You read.
Well, I have one copy just now, and then I am reading.
Yes.
No, that nahi okhane. Larger bench ta nahi.
Yes, you have given us.
Larger bench.
Another copy you gave us.
Arekta copy tale ache judgeর কাছে।
Which paragraph you are wanting to show?
मतलब আচ্ছা আরেকটা কপি জজের।
দাও। এটা আমায় দিয়েছিল, আমি হ্যাঁ প্যারাগ্রাফ
211, my lord, at page
158.
Page, my lord, 158.
211.
Paragraph 12, page 158.
Yes.
Paragraph 212, last paragraph.
That's it.
Tarak Chandra Koron, Supra, the question for consideration was, after School Service Commission Act 1997 came into force, would appropriate appointees get the benefit of higher pay scale despite being interviewed in the selected in pass category.
This does not apply to him.
Yes, Lord. Now, Lord, thereafter, Lord, subsequent all paragraphs that has been discussed, Boishali and others, and Shobik Ghosh. 211 to কত গেল? 211, 12, Malab, all are regarding the discussion. 13, every.
Ultimately, what was said?
13 says the selection test only in the pass category, 2013, Malab, 213.
Peda?
213, page 159. Same, 159. Page.
Yes, selection
Test
test was
selection
only in
test,
pass category.
pass category.
Yes.
There was no vacancy in post or honors graduate or postgraduate teacher in the physical education.
Oh.
Mala got him,
No, that is
159.
not telling with my.
No, certainly, Malam,
That is
same
for
page.
another-
159. Oh, acha, acha.
So the paragraph start with the relation.
Oh, total সময় মিলছে না।
কেন ওটা
The selection test, yes.
The selection test.
ওটা কি এসসিসি অনলাইন?
তারমানে
My lord says SCC online. I have a copy.
Yes, got it.
The selection test was only in pass category. There was no vacancy in the post of honors graduate, postgraduate teacher in the physical education. Admittedly, Tarok was a postgraduate teacher, degree holder in physical science in 1998 when he participated in the selection process. For educational teachers, there was no vacancy in the post of honors graduate or postgraduate. The learned Singhla dismissed the writ petition on that ground that after the Act 1997 came into force, there had been different categories for appointment or extension of benefit of higher pay scale because the government improvement of quality is no more permissible. All the things are subsequently discussed with Tarak Chandra and others. Up to 238. Up to 229, that has been discussed detail.
Yes.
Thereafter, my Lordship, kindly, that was subsequently all paragraphs that has been discussed.
Now, what was the conclusion?
Conclusion.
My Lordship, kindly turn paragraph 238 at page 168.
Yes.
Got it, my Lord?
239.
Justice Indira Banerjee, as his Lordship then was, before her ladyship elevation as Chief Justice of Madras High Court and subsequent to the Honorable Supreme Court of India, authored the aforesaid judgment and his subsequent decision of Shampa Sahu Mondal Supra revisited the issue.
Again, it was discussed. Ultimately, what was held?
Now, lastly, that is my submission to show 272D.
Yes.
That is paragraph, page.
Yes, 2D is your submission.
Yes. Page 186 of my.
Very confusing. Very confusing.
Well, larger bench passed this order. What I will do, my Lord?
Has to be read with the government order dated 3rd June 2002.
Please place 2D.
We have the view that Tarak Chandra Roy Supra has been correctly decided. We are of the.
What was decided in Tarok? That whoever has entered after 1997, the appointees get the benefit of higher scale of pay despite being interviewed and selected in past category. That was Tarok's view.
Yes.
So Tarok's view was upheld. Right?
Yes. As a physical teacher, past graduate.
Now, kindly come to 212. Come back to. What was the question for consideration?
Yes.
In Tarok, question for consideration was after the SSC came into force, would the appointees get the benefit of higher scale of pay despite being interviewed and selected and pass category?
Yes.
He will not get.
Yes.
That was what decided in Tarok.
Yes. Because
Okay.
physical education is a pass category subject.
Pass category. This was the now. We are of the view Tarok has been correctly decided.
Thereafter, Lordship kindly for a moment 213 paragraph.
Mr.
Paragraph
Chattopadhyay, this observation itself is contrary to Boishali.
213, Lordship kindly.
Boishali has been upheld by the larger.
Paragraph 213 next, next.
Yes,
212, thereafter 213. The selection test only in pass category. There was no vacancy in the post of honors graduate, postgraduate teacher in physical education. So,
where you are reading?
213 paragraph.
There was no.
Admittedly, Tarok was a postgraduate degree holder, physical science, and in 1980 a participant. So, whatever may be the postgraduate teacher, if he enhances qualification, he will not be entitled because physical education is a postgraduate subject.
On such consideration of division presided কি বলছে
বলেছে আরো খানিকদিন আগে
এই ভিউটা তো ইজ রং
হ্যাঁ এইটা অন সাচ কনসিডারেশন অনুযায়ী প্রেসাইডের চিন্তা হচ্ছে সেটা হোল্ড করলো
So your argument is if Tarok had been upheld, then he is not entitled.
Because postgraduate teacher.
But read the total. We are of the view that Tarok has to be read along with government order of 3rd June 2002. Which is that, sir?
That is the, my lord, the I have given, my lord, the act and notification. That is, my lord, the I tell you, ROPA 98, first amendment 13 July, second amendment 3rd June.
3rd June?
Yes, 3rd June, my lord, that is page 8. Page, yes, page 8.
Yes. What is this? Government has the honors graduate teachers on honor, including madrasa, appointed through WBSCC. You are not appointed.
I am not appointed. That is not applicable all along, my lord. Either 13 July or 3rd June, that is not the relevant, my lord, in my concern. Only staff pattern, my lord. The learned single judge also will remand the matter.
Mr. Chattopadhyay, kindly, our question is, anything else you want to show from this? Your contention is Tarok has been upheld. He has entered into graduate course, physical education. He cannot get postgraduate.
Repeatedly, court observed that the higher court does not create a legal right. Repeatedly.
Very good. Then what happens to Boishali, Mr. Chattopadhyay?
Because the court observed Boishali that has been upheld by the bench and also and not only that, if your lordship page paragraph 261, division bench, larger bench observed when the post of which appointment is made does not require a candidate with honors or postgraduate degree, the state cannot saddle with the financial burden.
Where is that?
Paragraph 261.
In the state of West Bengal versus Ganesh Samanto?
No.
How does it
when the post for which appointed?
When the post for which appointment, page 81 in my
own paragraph?
Got it, page 181.
181.
Paragraph 181.
No, page 181, paragraph 261. My lord, Justice Chatterjee.
261 starts with the state of West Bengal.
It is not my lord, it is from the SCC.
When the post for appointment, yes, when the post for which appointment is made does not require a candidate with honors, the state cannot be saddled with. In fact, candidates with honors would be overqualified. So, Tarok, in this case, it was said that I don't know, it is very confusing for me.
Confusing, my lord. I have gone through in detail now, it is very confusing. Very confusing.
Mr. Chattopadhyay, why you are relying on this? Kindly come to the stay application, the order impugned. Of Justice Hiranmoy Bhattacharya. Paragraph 7, page 147.
Two part, my lord, one, my lord,
issue.
that part now is completed, whether the correspondence notes will be allowed.
8 March 2000. That
has been allowed.
That is, my lord, that is allowed by the learned single judge.
Single judge, that is not applicable because
That is,
it is
Acha. And so far as approved staff pattern.
approved staff pattern.
Approved staff pattern, Mr. Chattopadhyay, for physical education, approved staff pattern will not apply.
I'm not, my lord, staff pattern, certainly staff pattern in physical education, because only one teacher. He is saying there are earlier 3 teachers, now only one teacher. So I am entitled. My question, whether you have the MPA, whether you will be entitled to higher pay scale, I am not. I am saying not.
Oh, I
because
see.
in view of the larger bench.
But Mr. Chattopadhyay, if you say that, order of Justice Pranab Chattopadhyay has attained finality.
Well, that has also been considered. That has also been considered.
In this
yes, special bench.
Where is the bar? Oh, you are saying Tarok Rai upheld? All nobody can get.
Yes.
272 273 হবে এই যে এর ফর এক্সাম্পলটা দিয়েছে এই এক্সাম্পলের এখানে
Staff pattern
for example, a teacher joined with a postgraduate degree. During his service career, teacher enhanced his qualification claim as scale up on the basis of said degree. Said claim has to be decided on the basis of relevant rule existing at the time of acquiring his higher qualification. If he joined the school with a postgraduate degree after the government he will not be able to entitled to postgraduate scale of pay unless teacher is covered by the government order.
It's covered. উত্তর কমিশনের মারফত এনগেজমেন্ট হয়নি, তাহলে ওর ক্ষেত্রে বাট যদি তখনকার ওর সার্কুলার পারমিট করে রিজেন্টটা এখন স্টাফ প্যাটার্নটা যে অ্যাপ্লাই করবে না, where is that circular staff pattern will not apply in respect of physical education?
Page 10 of my list of my that compilation, circular compilation.
Yes.
10
with that circular.
2 post.
2 post.
Qualification must be such and such. So there are
other group 2 post, but divided
one can be
postgraduate, one honors or postgraduate.
Yes.
But
now, Mr. Chattopadhyay, kindly come to paragraph 272. 272, my brother has shown. A. Enhancement of pay on acquisition of higher qualification during the service career is dependent upon relevant rules operating at the time of acquisition of higher qualification and cannot be claimed as a matter of right in the absence of rules. Now, for example, a teacher joined with postgraduate degree and during his service career, teacher enhanced his qualification and obtained higher scale on the basis of the said degree. The said claim has to be decided on the basis of the relevant rules existing at the time of his acquiring such qualification. If he has joined the school with a postgraduate after 12th February 99, he would not be entitled to postgraduate scale unless he is covered by the circulars of such and such and such. Any other interpretation would encourage a backdoor entry. A teacher upon acquiring can always complete in the, then again in view of Tarok, it has proceeded. So it says Tarok is upheld in respect of a person who has entered into service prior to School Service Commission Act as in this case. His case will be guided by the circular
Three of the ROPA 12-3, my lord.
in that case, he becomes entitled.
Tarok is also before School Service Commission Act.
Tarok is?
Tarok Chandra Roy. That is upheld by the larger bench.
Tarok's entry was in through School Service Commission.
No. Tarok Muslim.
Yes, that is quoted in your judgment. Paragraph 211. এই যে paragraph 200 and
appointees, not Tarok. Tarok not. So Tarok Malay joined in 1999.
হ্যাঁ কমিশন চলে এসেছে।
Automatically, 12-3, my lord, in subject or group. That is, my lord, now come.
But Mr. Chattopadhyay, Tarok, this judgment in Utpal Kantikaran does not stand in the way. There are two divisions, one after commission, before commission. So after commission, if Tarok's view is upheld, then nobody can get postgraduate scale of pay in physical education. Because in physical education, there is no entry. But
because physical education is a postgraduate.
Yeah.
Not it is the honors and
PG category.
Yes, PG category.
The physical education, there is
government's view is on
arts and postgraduate category.
Yes.
All category would be postgraduate.
Yes.
অনার্স এন্ড অন্যগুলোতে কি আছে, অনার্সে যদি থাকে সে পোস্ট গ্রাজুয়েট ডিগ্রি অ্যাকোয়ার করলে পেয়ে যাবে।
মানে এটা হচ্ছে 1997 এর পর থেকে এটা ভাগ দেওয়া হলো যে who joined only in honors and postgraduate, if he improved his qualification in the subject relevant to his teaching, then only he will get a higher scale of pay. Utpal Chandra Kar. But who, being recommended by the School Service Commission, was appointed in postgraduate category, he will not get.
Will not get any benefit.
He will not get.
সেটা contrary to বৈশাখ।
And who joined prior to promulgation of School Service Commission Act, then his case will be decided on the basis of extant rules.
His entry was prior to School Service Commission.
Then
the court's view is as per the relevant rules.
His case value will be favored under the 12C, otherwise not.
Under
12C of the ROPA. 12-3.
All
ROPA.
Teachers.
All teachers, subject or group. Otherwise, my lord.
First paragraph, first page. 12.3, I have given the compilation. 12.3, page
including physical.
5. Page 5.
All
ROPA 98.
All teachers included.
তাহলে
Utpal Kantikaran will not be applicable here.
Not applicable.
And Tarok, if
also not
was appointed on the basis of recommendation of 1997, Tarok will also be not applicable here, and his case will be governed as per 12.3 of ROPA.
Only that is the way. This judgment is very confusing.
To read it intently.
So many,
we all are reading from this portion, from this
top to bottom. We are not
reading the entire.
And all of the larger bench, another division bench presided over by the Honorable Justice Harish Tandon, also one of the member of the larger bench, decided that physical education teacher is entitled.
Is
physical education teacher is entitled.
Even after 1997?
Yes.
এটা করি
Yes, 11 paragraph page.
Utpalkantikkaran is judgment dated
Judgment date
23rd December, decided on 7th February 24. এটা কবে? আচ্ছা, the which paragraph?
and which Utpalkantikkaran also has been considered, and that has been that is paragraph কোথায় আমি আমারটা কোথায় সব দাগ দেওয়া ছিল তার
This is BSc Bio.
BSc Bio.
Where you also answered the
এ বকুল সিং তো না 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 BSc Bio না আরে বাবা না না এটা ফিজিক্যাল এডুকেশন তো
বৈশালী ব্যানার্জি মালার
ফিজিক্যাল এডুকেশন
হ্যাঁ
ফিজিক্যাল
No, page 2, last paragraph. Respondent herein acquired graduate degree in BSc Bio. Pass, 1995.
BSc Bio, next page. Subsequently acquired BPA degree from Banipur under the Calcutta University.
Subsequently have a BPA degree.
And acquired a master degree to 2001 and 2, which was a regular 2 years course pursuant to the advertisement school service commission.
This is also entries pursuant to school service commission.
Also, my lord, even then, my lord, the division
Where? We find that the case of the comes under the purview of the aforesaid circular. That circular is 3rd November 2004.
3rd November 2004 also in my compilation. That is, my lord, continuation after 12/3/1998, 13 July, 3rd June 2002, then to 3rd November 2004. That is, my lord, the step-by-step amended by the government that the
given in this.
I have given, my lord, on all the circular I have annexed in this compilation. I want to compilation that is
no
3rd June.
How can Utpalkantikkaran be applicable here?
The division has quoted that. Logically, my lord, the page 2. Ultimately, that a larger bench in Utpalkantikkaran answered the reference and also wait to judgment case.
Decided, yes.
Special bench
answered the reference.
Pointer. ওটা কোড করেছি yes that has been quoted the larger bench judgment subsequently টা কোন প্যারাগ্রাফ বলো তো subsequently the said circular as indicated was revised 3rd November 2014 in the following.
Come to page 3.
Page 3,
middle of the page, after obtaining the postgraduate degree in physical education. After acquiring the obtaining position, a representation made to grant postgraduate rejected by all. Respondent approached filed single judge held. Respondent acquired in the year 2000, much prior to coming into effect of commission. The authorities cannot reject the prayer of his. আপনি ছিলেন? You are good, Utpalkantikkaran.
No. আমি ছিলাম।
আপনি ছিলেন?
He যদিও BA pass কিন্তু was appointed as an assistant teacher in physical education.
He was appointed as assistant teacher in physical education.
School service commission.
এবার কমিশনের পর এনসিও কমিশনের পর তারপর অ্যাকুয়ার করলো, ও অ্যাকুয়ার করেছিল এক্সপেন্ডিচার অ্যাক্টের আগে।
কবে চাকরিতে ঢুকলো সেটা 99 এটা অফার আচ্ছা said appointment which was duly approved in the year request was made.
তারপরে 2001 এ করছে, আমাদের স্কুল সার্ভিস কমিশন অ্যাক্ট তো 97 এ।
BPA in view of the judgment, we find that the case of the appellant comes within the purview of the aforesaid
physical education 1998 এ তারপর মাস্টার হচ্ছে 2000 2001 রেগুলার
সিম্পলি তো বললাম সিম্পলি আই এম নট এ ক্যান্ডিডেট অফ স্কুল সার্ভিস কমিশন
summer vacation course
that has been single bench uphold that, the also by the others coordinate bench division bench uphold that is the permission.
When the restriction has been made, before that he completed the course.
Okay.
Larger bench where MPA discussed in Boishali Banerjee and the Bhaskar Chakraborty, in details 7 to 8.
May have been discussed, detailed, but what calls out from the judgment?
So not only that, strictly after completion of that paragraph regarding Boishali Banerjee and Bhaskar, next paragraph, it is automatically the conjunctive. Observe, in our considered opinion, acquiring higher qualification does not create a fundamental right, nor does create a vested right.
That's true.
That has been quoted in larger bench.
But what do you say about this judge after court?
I have not gone through the people.
দিলাম তো কপি দিলাম
ধরে কি করে
রিপোর্ট হয়েছে তো রিপোর্টেড জাজমেন্ট
রিপোর্টের জাজমেন্ট আমার অত বিদ্যা বুদ্ধি নেই আর আমার এর থেকে বলার জায়গা নেই
The learned advocates appearing for the